Hello, my name is Earl McCoy from McCoy Law, and I'm coming to you tonight just throwing together a quick, maybe not so quick, unscripted video. I don't have a script, but I do have some things I want to talk to you about just because, Governor Eric Holcomb's most recent executive order goes into effect tonight, and that is going to change our lives yet once again. The COVID-19 situation has just affected virtually everything we do. And it's funny because it's made a lot of our lives have to go virtual. We are kind of lucky in some respects that the technology today allows us to be able to share ideas and get things done online in a way that, we wouldn't have been able to do if this pandemic had hit 20 years ago. So we are lucky in that respect, and we need to keep that in mind. The reality is, though, with so much uncertainty, I just don't know much of anything for sure. I'm not certain of hardly anything these days. In fact, the only thing I'm really certain of is that bitch Carol Baskin killed her husband. But in all seriousness, there are some things that we definitely need to talk about because the executive orders are affecting our lives in many more ways than you might think and affecting our legal rights in a number of issues that are incredibly important. Now, the governor's order does recognize that law firms are still essential businesses, and in fact, I think everybody understands that, particularly in this time. Many of my clients need us now more than ever before. And so for that reason, McCoy Law, the team here has been together and we're staying put. We're going to be open every day. We are sometimes working from home, sometimes not. There are some things that we just can't do from home. If you have a court hearing, we have to go to court. And there are still cases that are being heard. And we're here every day to take phone calls and answer your questions and address the issues that do arise. And there are issues arising every day. Just today, I had a conference with one person that needs a will done, and now is the time to do that, although there are more complications and nuances that we have to address trying to do a will from afar because it has to be witnessed, right? Yet the changes that are in place to go into effect tonight really do impact that quite a bit. The good news is, here at McCoy Law, we have the technology already in place. We're ahead of the game. We have the ability to do almost everything remotely. Obviously, in those emergency hearings where we have to go to court, you're just going to have to come down to the courthouse, and those issues, luckily, are few and far between because we can do almost everything remotely now. And I want to show you a little bit about that. But before we get there, let's take a quick look at Governor Holcomb's executive order because the news doesn't really go into a lot of detail. So I want you to know where to find it so you can figure out what you're allowed to do, what businesses are going to be open, what businesses are not going to be open. If you have if you are a business person, a small business owner, what's it take to be open now, even if you are what's considered an essential business? Because there are definite changes that go into effect at midnight tonight. So I'll tell you what, come on around here and I'll show you what I mean. Yeah. All right, so first off, I want to look at the governor's executive orders. All right, most importantly, we want to look at Executive Order 20-18. Now, I can tell you, you can find that by going to the governor's website. In his menu list, you can click down to Newsroom, just like here. Click on Executive Orders, and then it'll take you to the executive orders. The most important one right now, for most of us, is 20-18. It's the continued directive to stay at home. It is much different than what we had before. There's some significant changes. It didn't extend the timeline from the last timeline that was issued a week ago. But it did make some significant changes that are added restrictions that are noted in italics, okay? So if you skim down through this, you'll see that there are new rules for retail places in terms of if they're going to remain open, what they have to do to remain open. So that's important for any retail business. Campgrounds, previously, as you can see in this highlighted portion, they encouraged us previously to get outside, but you cannot be in a campground in a camper anymore or tents unless you have no other viable place of residence. That's the only time you're allowed to be in a camper now under the new rules. What's really going to impact us the most is the changes that that are in place for retail establishments. Retail businesses, all of this is new. The part about firearms is new, but it really doesn't say much except the Constitution can't really restrict it under Indiana Code. But with regard to retail businesses, unless it's providing the necessities of life, including groceries, and there's other things here, probably not going to be allowed to be open anymore, right? So we had some things that were open that are now going to have to close unless they carry a significant quantity of life-sustaining necessities such as food, medicine, and those kind of things. And then even the ones that are allowed open have all these new requirements. All these requirements go, get rid of this. How do I get rid of whatever? All right. So sorry about that, but a lot of new requirements that go into effect at midnight tonight, or 11:59 on April 7th, which is tonight. So keep that in mind. The restaurants, nothing's really changed there, but from a legal perspective, professional services have changed significantly, and that's found here on page 9 under professional services. Applies to lawyers, accountants, insurance companies, real estate services. Everything has to be done virtually by telephone now whenever reasonably possible. Anything that must be done in person is supposed to be delayed until after this healthcare emergency is over. So all face-to-face encounters should be postponed unless failure to meet in person will have a significant adverse impact on the client's legal or financial position. So from my perspective, based on what I deal with most of the time, and honestly because of the technology we have available to us here at McCoy Law, for the most part, the only thing that's, that we're going to need to see you in person for, based on the new rules, is to go to court. And we are going to have to go to court sometimes on emergency hearings. I just talked to somebody today that yesterday had a child removed from them by Child Protective Services or DCS. I have clients that are have initial hearings coming up on criminal cases. A lot of criminal hearings are still happening. So we do have the need to go to court essentially. Please note, it's not a change. It's been the rule all along, but people have been confused about it. Essential travel includes travel required by law enforcement or a court order to transport children pursuant to a custody order or a custody agreement. It's incredibly important. We've had some people who've tried to deny parenting time or withhold children because of the coronavirus fears. Now, it's important to note, if both parents agree, if somebody's sick at one household and not the other, and you don't want to send the children, that makes sense if both parties agree. But if you don't agree and there's a court order, transportation is still allowed. The governor doesn't have the authority to trump a court order, really. That's the executive branch and the judicial branch. Two different branches, separation of powers. Now, the Supreme Court could, void any custody orders if they wanted to, but they haven't, and they're not going to. In this executive order is a lot more information for small businesses such as myself. If you are going to stay open, the requirements of what you have to do in order to stay open are all set forth in detail in this executive order. So take the time to read it. Be familiar with it. Don't be surprised at certain businesses that are going to be closed, and even the impact at our office. We haven't had as many clients coming in. Some people have still come in person. Most of our clients we're dealing with their legal issues via video conferencing or over the phone or email, and almost everything can be done that way now due to certain rulings that have been made by the Indiana Supreme Court. So I want to direct you to how to find those rulings as well. So if you go to the Indiana Supreme Court page, and let me just back up here, I Googled this earlier. So if you Google Indiana Supreme Court orders, this is Bing, use Google, whatever. You'll see Chief Justice of the Indiana Supreme Court here, but click on this first link and get to the Indiana Supreme Court orders. Take you to this. It will take you to this page. What you're going to want to be interested in are the orders listed under other orders. So click on that here. It'll take you down to a series of orders that have been issued by the Indiana Supreme Court. Most of them really aren't going to concern you, but there are several orders that are incredibly important to everyday people, particularly people that have custody cases, child support orders. And those orders were issued on March 31st of 2020. I want to direct your attention here to first this March 30, 2020, 20S-MS-238. This order involves custody and parenting time, and it's very important. All right. So custody and parenting time orders, according to the Supreme Court, remain valid and they're in full force and effect. It says here, shall remain in place during the pandemic and shall be followed. All right, look at what I've highlighted here. This is important. When a court order says shall, it's mandatory. It's not optional. You have to abide by it. If you don't, you can be found in contempt, and the court has a lot of authority to impose a lot of different penalties for contempt. All right. So with that being said, pay attention to some of the other things. So we noticed when spring break was extended that many people are saying, hey, it's my spring break. Now spring break's 3 weeks long because the schools are closed. No, it's not. Spring break's still 1 week. The school was closed for other reasons. Now the schools are closed for the rest of the year. Does that mean summer starts early? No. The Supreme Court has addressed that. It's right here. The school calendar published at the start of the academic year for each child's school district shall control. That's what sets your summertime extended parenting time, okay? So if you want to know when your summer vacation starts, it doesn't start now because the kids are out of school, because the kids aren't out of school, for one. They're still doing e-learning, distance learning. But in any event, the Supreme Court has said school is out when they were originally supposed to be out. So I'm in Lafayette, Indiana. Lafayette School Corporation original calendar that's still available on their website says the 2019 to 2020 academic school year was supposed to end on May 19. That's when the school summer vacation starts. School summer vacation ends based on the school's calendar for next year. That's how you divide your summertime, okay? Now, the court does note if both parents or any other parties to the court case, which could be grandparents who have court-ordered grandparent visitation, if you believe there is a reason to temporarily modify or change the terms of a custody or parenting time order, then you are certainly allowed to agree to that. You can informally agree in writing to temporarily modify it, okay? But how do you enforce that? Well, that's a little bit up in the air. We don't know. Because it says this temporary agreement may be filed with the court, but it's not necessary so long as you both keep the agreement. Well, if you don't agree, or you get midway through and you don't agree, or one side says, I'll agree, you give me these days, I'll make it up to you later, then later they say, I don't agree anymore, you don't have anything enforceable. Not under this language, not in my opinion. So really what you need to do is if you agree, get a hold of somebody like myself, McCoy Law, get a hold of another lawyer if you can find one that's working appropriately, get the information reduced to writing, and get it filed with the court. Of course, if you're trying to do that on your own, you're going to struggle because agreements and petitions and motions should be filed electronically. Most regular people aren't set up to file electronically. It takes an attorney to do that. Quite honestly, in my opinion, you're going to want an attorney to draft up these agreements anyway to make sure they're drawn up correctly and they can be enforced, right? Because chicken scratches on a piece of paper, while the Supreme Court says here that can be okay, it can also be problematic in terms of interpretation under Indiana law, because a judge at some point is going to interpret these agreements in light of Indiana law. You're going to be bound by the law. So it's really it's in everybody's best interest, and most importantly in the children's best interest, to have them reviewed by an attorney, drawn up correctly, and filed with the court. It also says here, and this is important, if the parties cannot reach a temporary agreement or do not remain in agreement, right? This other agreement went to hell in a handbasket. Then either party may file an emergency petition to modify the existing order. That's one of the reasons McCoy Law is open. That's why we're here every day. We're here for those emergency situations that arise. If they arise, reach out to us. We can explain what you need to do to file an emergency petition. Of course, you're going to be best off to do that with an attorney. And the courts are available for emergency hearings. All right, next thing is child support. Many county support offices, as I noted, are closed. They won't accept payments in person of child support, but you still owe the child support. You have to pay it. Inability to pay can be a defense to contempt, but it doesn't excuse the child support. You're just falling farther behind. So your child support payments, just like it says here, has to be paid online, by telephone, by mail, or other locations. It gives you a link so you can click on it if you're on this page to pay your child support payments. It does say parents who are unable to make their payments in full or any child support payments as a result of the pandemic may file emergency petitions to modify child support with the court. All right, this is incredibly important. Again, this is why McCoy Law is open. Give us a call, get the petition on file. Indiana law is very specific. You cannot modify child support retroactively without filing a petition. You get a petition on file, the child support may not be modified for a month, but it will be modified back to the date you filed the petition. That's incredibly important. The court realizes these are emergency issues that can be filed with the court now, and if need be, you can have a hearing on them now to get these issues addressed. All right, next big thing that I want to talk about, it's not in this order, but in the courts, another important order, particularly right now with the pandemic, in my mind, is the ability to sign a will. Now, wills have to be signed and witnessed. Powers of attorney have to be notarized. These documents have to be done with certain legal formalities. However, it's difficult to do those when you can't go into an office. So now the Indiana Supreme Court has given us a way during the pandemic to do these things remotely, but there are very specific rules about witnessing wills remotely. And if you don't have a will, you need to do one, particularly if you have children. You also potentially need designation of healthcare representatives in place and powers of attorney, because many people who are not dying are still on ventilators for a significant period of time while suffering with this illness. And if you're on a ventilator, you're incapacitated. You can't pay your bills. You need somebody to handle your finances. You need somebody to make your healthcare decisions, because you just can't make them on your own when you're on a ventilator with a tube in your mouth. And the most important thing to think about in that regard is, spending a little bit of money now to have a will properly drawn up is going to save you tons of money later. It's going to cost you a third or a quarter of what it would cost you if you don't have those documents in place and your family members have to reach out to McCoy Law or another firm like us to file for an emergency guardianship to provide for these things, to put somebody in charge of making your decisions if you don't make them yourself ahead of time. So emergency guardianships, if you need them, we're going to be here. We'll do those for you. But it just makes a lot more sense to draft a will ahead of time, and we can we can sign these things remotely as long as we follow these rules. So I'm pointing out that the rule exists, the emergency exists. We are allowed to do things remotely. McCoy Law has the ability to do that with video conferencing. Not everybody does, because the things have to be done like it says here. Remote witnesses and remote testator must be positively identified to one another, and you must be able to see the execution of the document. That requires video conferencing. Can't do it over the phone, can't do it over email. So video conferencing is what we need to do, and we have the ability, just like I'm recording this, to record that, to be able to produce that in court later if we need to. The other important thing to realize is after this is all over, you still have to come in person within 90 days of the health emergency expiring to get in and sign the documents the old-fashioned way, right? We may need to change them at that point, we may not, but we can get them done now, and then we just need to finalize them again later. So these are very important things to consider, especially right now with this dangerous virus running rampant throughout the community and throughout the country. Take a few minutes, think about it, give us a call, schedule a free consultation. Again, to do wills, power of attorney, designation of healthcare representative, living wills, other advanced directives, it's just the right thing to do. It's not very expensive. It's certainly a lot more inexpensive than what your family will be faced with in the event you don't take these steps now and you end up in a situation where you're incapacitated or deceased and the family has to run out and either file a lawsuit to open an estate or file a lawsuit to open an emergency guardianship. All of those things are going to be much more expensive, and you lose control at that point. by taking the steps now to do these things properly, even remotely, it gives you the chance to exert that control over your property and make sure your wishes are honored. So I just wanted to take a minute to show you how things are changing at midnight tonight. And I think these are important changes that most people don't know about. The news just doesn't really talk about the fact that you can do wills remotely. They don't talk about the custody orders and modifying on an emergency basis if you can't pay. And I'm afraid people mistakenly think that it's going to be forgiven because a lot of other things seem to be forgiven lately, right? Government's giving out money left and right. Well, wrong. Your child support is not going to be modified retroactively. That law has not changed. The court orders, the Supreme Court specifically say that those existing orders remain in full force and effect unless they're modified by agreement or modified by an emergency motion. So take these matters seriously. Don't wait. Wait could be disastrous. Waiting could be disastrous. So give us a call here at McCoy Law if you need us. We're going to be here. There's a few other things I want to talk to you about over here. I just really want you to understand we're here for you, and we're here for you for a reason. Whether children have been taken by CPS, whether you've been arrested because criminal cases are still going forward, whether you have family law issues that are being impacted by the travel bans or any other orders, whether there's a need for an emergency modification of child support, whether there's a need for an emergency modification of the parenting time order, give us a call. I mean, we're here to help you. We can do much of it very cheaply. And then the other thing that we can do here at McCoy Law is mediations. And we can use the video interface that we have. And this video has gotten kind of long, so I may just break it off into another video. But the video conferencing that we have is much different than, say, Zoom or anything else that's out there for free. It's at no cost to our clients because we bear the cost of that. But it gives us the ability to have communication with our clients and with the entire group, including the mediator. Or if I'm the mediator, I can talk to both lawyers, both parties. We can do mediation without lawyers if both parties agree to me as a mediator. We can do this all via video conferencing, but the system I use allows us to have individual secret conversations, which is incredibly important, particularly when attorneys are involved in the mediation. Sometimes, if you got a client that's at their home, an attorney that's at their office or their home, another client that's at their home, and the other attorney's at their office or their home, and the mediator is somewhere else altogether, we can all still communicate through this interface, but individual conversations via chat can happen between the attorneys and their clients, the attorneys alone without the clients, the attorneys and the mediator, one client and the mediator if there's not an attorney involved. All of these things can happen in a secure format so that, because the reality is sometimes in mediations you really need your parties in different rooms. You need the ability to talk to your lawyer privately, and that's just something you can't do on Zoom or what a lot of other law firms are trying to use, and it just doesn't work. So if you're having trouble reaching agreements, remember the Supreme Court's already said you can file for an emergency motion if you need to, but I do suggest that you try a settlement conference or mediation with somebody such as myself to see if we can work it out without the need of involving the court and without the need of anybody really getting out and being exposed to the virus any more than they have to be. I hope you find this information helpful. Please check out our YouTube page, click subscribe. If you like the videos, hit like, but keep checking back because I plan to do a whole bunch. I have the opportunity now with the time and the technology to go into a lot of the issues that I deal with on a day in, day out basis. And some of these things can be avoided if people just use a little bit of common sense, and that's why I'm here. Again, I don't have any independent proof about Carol Baskin, but I'm pretty convinced, and I think you might be too. But in any event, I hope you're finding some time to have fun, enjoying your children, and if you need McCoy Law, we're here. Give us a call, shoot us an email, shoot us a message online. Message me on Facebook, YouTube, I don't care. We're here to help you. This is a service industry, and these are the reasons I'm here. So give us a call if you need us. Thank you.